In the previous sections, we explored the various ways individuals and entities hold rights in real estate. Understanding interests and estates in land is fundamental to grasping how property is owned, used, leased, and transferred. These concepts form the very foundation of real property law and practice. An interest in land refers to any combination of the bundle of rights: the right to possess, use, transfer, encumber, and exclude. Interests in real property include ownership interests, such as estates, and non-ownership interests, such as encumbrances or government-imposed rights like police powers. An estate in land goes one step further, because it includes the right of possession. Estates are divided into two primary categories: freehold estates, which imply ownership and may last indefinitely, and leasehold estates, which involve possession for a limited period of time without ownership. A freehold estate implies ownership and can last for an indefinite duration. The most common type is the fee simple estate, which represents the highest form of ownership in real estate. The fee simple absolute estate grants full ownership that is transferable, inheritable, and perpetual, subject only to legal restrictions like zoning or taxation. A defeasible fee estate is similar, but may revert to the original owner or heirs if specific conditions stated in the deed are violated, such as requiring the land to be used for a church, school, or park. A life estate, by contrast, lasts only for the lifetime of a specified person, known as the measuring life. The holder of a life estate or life tenant enjoys nearly full ownership rights during their lifetime, but cannot transfer the property beyond their death. When the life tenant dies, the property either returns to the original owner, reversion, or passes to a third party named in the deed, remainder. Conventional life estates are created by private agreement, while legal life estates arise automatically by operation of law to protect family members. There are two forms of conventional life estates: ordinary life estates, which end when the life tenant dies, and per autre vie estates, which last for the life of another person. A legal life estate is not created by the property owner, but instead by state law. These estates protect surviving spouses and family members, ensuring they are not left without shelter or financial security upon a loved one's death. There are three main forms: homestead, which safeguards a family's primary residence from certain unsecured debts or creditors; dower and courtesy, which historically gave surviving spouses life estates in the deceased spouse's property; and elective share, which allows a surviving spouse to claim a statutory share of the deceased's estate, even if excluded by a will. While freehold estates convey ownership, leasehold estates convey possession for a limited time. Leasehold estates are personal property interests created through a lease agreement between a landlord, lessor, and tenant, lessee. The tenant gains the right to use and occupy the property under agreed terms, but does not own it. There are four principal types of leasehold estates: estate for years, a tenancy for a definite period with a specified beginning and end date. It terminates automatically without notice. Estate from period to period, also called a periodic tenancy. This lease renews automatically from one rental period to the next, such as month to month, until either party gives proper notice to terminate. Estate at will, a flexible arrangement with no fixed duration that continues as long as both parties consent. It ends with notice or upon the death of either party. Estate at sufferance occurs when a tenant remains in possession after the lease has expired without the landlord's consent. If the landlord accepts rent, it may become a periodic tenancy. If not, the tenant is considered trespassing and may face eviction. Together, these estates illustrate the full range of property interests recognized by law, from absolute ownership to temporary occupancy. Real estate professionals must understand these distinctions to draft valid contracts, advise clients, and ensure clear title in every transaction. Review summary. An interest in land represents a legal claim or right involving real property. When the interest includes possession, it becomes an estate. Estates are classified as freehold ownership or leasehold possession. Freehold estates include fee simple and life estates. The former is the highest and most complete form of ownership, while the latter lasts for the duration of a person's life. Legal life estates, such as homestead, dower and courtesy, and elective share, arise automatically to protect family members. Leasehold estates grant the right to occupy property for a specific time and include estate for years, periodic tenancy, estate at will, and estate at sufferance. Mastery of these forms of ownership and possession is essential to understanding how property is controlled, transferred, and used under the law. Discussion. Why do legal life estates exist, and how do they differ from conventional life estates? Answer. Legal life estates are created automatically by state law to protect surviving spouses or family members, while conventional life estates are created voluntarily by agreement between parties. What makes a fee simple absolute the most complete form of property ownership? Answer. It provides full ownership rights that are transferable, inheritable, and perpetual, subject only to lawful restrictions such as taxation and zoning. How does a leasehold estate differ from a freehold estate? Answer. A leasehold estate grants possession for a specific time without ownership, whereas a freehold estate grants ownership rights that may last indefinitely. What happens when a tenant refuses to vacate after a lease expires? Answer. The tenant becomes a holdover tenant under an estate at sufferance, and the landlord may choose to accept rent, creating a periodic tenancy, or evict the tenant. Closing remarks. The study of interests and estates in land reveals how deeply property law intertwines ownership, possession, and protection. From the enduring power of a fee simple estate to the temporary rights of a leasehold tenant, every form of estate serves a legal and social purpose. Understanding these differences helps real estate professionals ensure fairness, uphold clients' rights, and navigate the complex relationship between property law and everyday transactions.